I'd first like to introduce you. I want to thank everybody for joining the call today. I know it is extremely difficult to keep track of everything that is going on in the world, especially in the Middle East, now that America has started the air campaign against the Islamic State and some of the Sunni Arab nations of Jordan, Bahrain, Saudi Arabia, and the Arab Emirates have joined in the campaign. There is so much in the news and so much to follow, but we shouldn't keep our eyes off the ball of the Palestinian Authority and some of their plans. As you know, tomorrow will be the opening session of the General Assembly, and now that the physical war that the Palestinian Authority waged, and Hamas, Hamas, waged against Israel this summer is over, the Palestinian Authority are taking their plans to the diplomatic front. As we know, Mahmoud Abbas intends to introduce a plan to the General Assembly to call for the Security Council to adopt a resolution that provides Israel with 3 years in which to withdraw from all of Judea and Samaria and establish a Palestinian Arab state in that entire region. I know that Mahmoud Abbas was speaking at Cooper Union last night, and he said it's time for us to finally demand that Israel end the occupation. Of course, forgetting that, there have been many attempts from May 25th, 2000, with Ehud Barak to withdraw from all of the territories, to 2008, when Ehud Olmert made an even more generous offer to the Palestinian Authority. And at this time, the United Nations Human Rights Council in Geneva is working on a report of alleged Israeli war crimes committed during Operation Protective Edge. This will become the successor to the Goldstone Commission and the Shabbos Commission, and it is expected to provide a report at the Council's March 2015 meeting in support of the war crime charges leveled against the Jewish state at the Council's meeting in July of 2014. Here to discuss what tactics that the PA are planning to use to essentially impose Palestinian peace terms upon Israel, and whether or not the United States will veto a vote in the UN Security Council, and whether or not that will be sufficient to block the PA's plans, and whether or not we could rely on any other countries besides the United States to count on to come to defense, is Ambassador Richard Schifter. Ambassador Richard Schifter is a wonderful insider in the United Nations. He has served as the Assistant Secretary of State for Human Rights and Humanitarian Affairs from 1985 to 1992 in the United Nations. That was a position in which he played a key role in the successful U.S. effort to encourage the Soviet government to end the abuse of psychiatry, release political prisoners, end the practice of criminalizing political dissent, and to allow the emigration of Soviet Jews to Israel and the United States. All changes in Soviet policy that helped end the Cold War. And this story is told in a very exciting book written together by Ambassador Schifter with his Soviet counterpart, Anatoly Adamyshin. It's called Human Rights, Perestroika, and the End of the Cold War. In 1992, Ambassador Schifter received the Distinguished Service Award of the Secretary of State. From 1993 to 2001, the ambassador served successfully as Special Assistant to the President, Counselor, and Senior Director on the staff of the United States National Security Council, and Special Advisor to the Secretary of State. In appreciation of his work, the Clinton administration in leading the U.S. effort to organize the Southeast European Cooperative Initiative, he was awarded the Austrian Great Golden Decoration with Star, the Bulgarian Star Planina Order, and was designated a commander of the Order of the Romanian Star. Recently, Ambassador Richard Schifter serves as chairman of the board of the American Jewish International Relations Institute, or AJIRI, a wonderful organization that I am proud to be a member of. He has had a distinguished career as a lawyer in Washington, D.C. and in government. Since 2005, he served as chairman of the board of AJIRI. After receiving his LLB from the Yale School of Law in 1951, he practiced law in Washington, D.C. with Fried, Frank, Harris, Shriver, and Jacobson, and is now a retired partner of that firm. From 1981 to 2001, Ambassador Schifter held a series of senior foreign policy positions in the U.S. government. He represented the United States in the United Nations and gained an intimate knowledge of the workings of the UN, and in particular the efforts made by a grouping of states to ignore the humanitarian principles set forth in the UN Charter, and instead the use of the UN solely to embarrass the United States and to delegitimize the State of Israel. The positions the ambassador held from 1981 to 1986 and again in 1993 included representing the United States and the United Nations Commission on Human Rights, the UNESCO Committee on Conventions and Recommendations, and serving as Deputy United States Representative in the United Nations Security Council with the rank of ambassador. Without further ado, it is my pleasure to introduce you to someone who I'm proud to call my friend, Ambassador Richard Schifter.
Sarah, thank you very, very much for your kind words and for you and EMET to provide the opportunity for me to speak out on the subjects that are indeed of great concern right now. So let me begin my prepared talk. The 69th session of the UN General Assembly is now underway. Tomorrow, the so-called general debate starts. It is the initial period of each session in which heads of government will be delivering speeches. The general debate will last for a week. Among the speakers will be President Obama, as well as Prime Minister Netanyahu of Israel, and on Friday it will be President Abbas of the Palestinian Authority. From the activities in which the leadership of the Palestinian Authority has recently been engaged, and from announcements that have been made, it is quite clear that the Palestinian Authority plans to call upon the United Nations to replace the United States as the intermediary in peace negotiations with Israel. While we need to await the Abbas speech to know precisely what the United Nations will be asked to do, it is quite clear from statements made by persons in Palestinian leadership positions that the intent is to use the UN to attain a peace agreement that imposes the Palestinian demands on the State of Israel. What these statements suggest is that while the Palestinian side would consider further negotiations of a peace agreement, it will insist that the Security Council decide on one of their key demands in their favor before negotiations would start. What they ask for is a Security Council directive ordering Israel to withdraw within 3 years from the West Bank and East Jerusalem to the 1949 armistice demarcation lines, which are often referred to as the pre-1967 borders. That directive would take effect even if the peace talks produce no result. This approach would break with the idea that has for many years been viewed as the underpinning of the two-state solution, that the boundary line would be negotiated. It is appropriate to recall that in discussing the issue of a boundary between Israel and the future state of Palestine, President Obama has endorsed the idea of negotiating on the basis of the 1967 lines, quote, with mutually agreed swaps, close quote. That concept derives from Security Council Resolution 242, adopted in 1967, following the Six-Day War of that year. While calling for an Israeli withdrawal from occupied territories, Resolution 242 provides expressly for the right of all states in the area, quote, to live in peace within secure and recognized boundaries free from threats or acts of force, close quote. The wording of that resolution made it clear that the location of a new boundary line was to be negotiated. It is now 47 years later, but the principles that were appropriate for 1967 are equally appropriate now. Agreement needs to be reached on the drawing of secure boundaries and on guarantees against threats or acts of force. As for guarantees against acts of force, we need to keep in mind that in 2005, Israel's Prime Minister Sharon ordered Israel's unilateral withdrawal from the Gaza Strip and the dismantlement of all Israeli settlements in Gaza. Before long, southern Israel was the target of a continuing barrage of missiles and mortar fire from the Gaza Strip. It is therefore critically necessary to provide for the controls needed to guarantee the new borders against threats or acts of force as stipulated in Resolution 242. There is one other fundamental issue that will have to be resolved. Though often bypassed in discussions, it is truly the most serious issue. We need to note that a difference between the Palestinian parties, Hamas and Fatah, is that Hamas rejects the idea of a two-state solution, whereas Fatah purports to accept it. But while Fatah does indeed accept the two-state solution, it does so only for the short term. In the long run, it too wants the existence of the State of Israel terminated. Whereas Hamas wants to end Israel's existence through acts of violence, Fatah's idea is to reach that result through what it claims to be the right of return. That term is used as a call for the migration to the State of Israel of Palestinian refugees who left their homes during Israel's War of Independence and their descendants. At the beginning of that war in 1948, when the State of Israel was attacked by its Arab neighbors, word was sent out by the Arab states via radio, urging Arab residents of Israel to get out of the way of the invading Arab armies. Many of them followed that advice. Others wanted to escape from the battlefields without needing advice. Many of these refugees fled to the neighboring states, Lebanon, Syria, and Jordan. Let us keep in mind that any baby born in that year is now 66 years old. If the baby's parents had been 25 years old, they would now be 91. It is therefore not surprising that not many of the refugees of 1948 are still alive. The number is now less than 50,000. But they have lots of children, grandchildren, and great-grandchildren, totaling about 5 million. Thus, when we talk about the current population of Palestinian refugees, let us keep in mind that 1% are indeed refugees, while 99% are the descendants of refugees. If these millions of people were to migrate to Israel, they would, of course, create serious economic and social problems for the state, but would also end the existence of Israel as a majority Jewish state. It is not surprising, therefore, that Israel is simply not prepared to recognize that claim. When President Clinton in 2000 proposed what became known as the Clinton parameters, they provided that Palestinians do not have such a right, that they can settle in Israel only if granted permission by the Israeli government. Though the claim is often referred to as a right of return, The fact is that there is no such right in terms of legal meaning of the term. Those who claim the right argue that it was granted by the United Nations in the General Assembly Resolution 194, adopted in 1948, and can still be asserted. The fact is the General Assembly resolutions cannot grant anyone a right. Action by the Security Council is required to attain that result. Besides, if you take a good look at the wording of the Assembly Resolution 194, it really applied only to 1948 situations. Given that reality, why are we still dealing in 2014 with 5 million Palestinian people who claim refugee status? Why have they not been resettled? The answer lies in UN actions taken in 1949 and 1950. It was in 1949, with approximately 700,000 Palestinian refugees living in the adjacent Arab states, that the United Nations created the United Nations Relief and Works Agency, UNRWA, which was to provide the social and economic services needed to assist these refugees. It was a year later, in 1950, that the United Nations also created the Office of the UN High Commissioner for Refugees to serve all other refugees in the world. It would have been logical in 1950, when the Office of the High Commissioner was created, to place UNRWA under his jurisdiction. It did not happen then, and it has not happened since. For all these decades, we have had one UN agency limited to serving Palestinian refugees, and another single UN agency serving all other refugees in the world. What they have in common is providing social and economic assistance, but they have two profound differences. First, under the High Commissioner, refugee status does not pass from generation to generation. The Commission assists the refugees and the members of the family that live with them, and that is where the assistance effort ends. Second, the reason why the assistance effort can be ended with a minimum of hardship is that while the High Commissioner explores the possibility of repatriation, if that fails, he arranges for the resettlement of refugees. What all this means is that since 1950, Palestinian refugees and their descendants have been pawns in the hands of those who want to end the existence of the State of Israel. The UN has allowed itself to be used to accommodate these anti-Israel operatives who have deliberately prevented the UN from granting Palestinians the opportunity of support for their resettlement, an opportunity available to all other refugees worldwide. Let me add at this point that it is my understanding that at the negotiations with Arafat in 2000, President Clinton offered to raise billions of dollars to help resettle Palestinian refugees. As we know, Arafat did not accept the Clinton parameters. I've addressed the refugee issue at some length because of its critical importance. Polling of the Israeli public shows that a majority is prepared to support the two-state solution, but clearly on the assumption that one of these states will be majority Jewish. The answer to the problem posed by the descendants of Palestinian refugees who live in Lebanon and Syria and don't have equal rights there is for the UN to help them get resettled. Returning to September 2014, we should note that an interesting development took place last Friday. Mahmoud Abbas visited Paris and met with French President Hollande. Following that meeting, Hollande announced that France will submit a resolution to the UN Security Council to resolve the Israeli-Palestinian conflict. The question now arises whether the French draft resolution will largely reflect Palestinian demands or whether it will differ significantly from them. It is in this context that we need to examine the parliamentary questions that will arise when the Council deals with this issue. Under the UN Charter, there are two requirements for the adoption of a Council resolution. First, the resolution needs to attain 9 affirmative votes from the Council's 15 members. Second, there must be no negative vote from a permanent member, namely China, France, Russia, the UK, and the United States. A no vote by a permanent member is usually referred to as a veto. We should hope that President Hollande will not have France submit a text that the United States will be sure to veto. Thus, to avoid a veto, France will have to reach out to the United States and seek to develop a text that the United States will not disapprove. As it is, the Abbas proposal to set aside the basic principles contained in UN Security Council 242 of 1967 cannot be expected to win U.S. approval. That is why the French initiative may very well be important. If France and the United States find themselves in agreement, there's no doubt that the required 10 affirmative votes will be available. The only question will be whether China and Russia will be opposed. But what if the French proposal is potentially so damaging to Israel that the United States will not agree? In that case, it is quite possible that there will be no Security Council action in 2014. But the situation will be different in 2015, when the Council membership can be expected to be far less friendly to Israel than the current Council. As you may have seen from last Sunday's Washington Post, we can expect Venezuela to be a member of the Council. Friendly South Korea will be replaced by unfriendly Malaysia. There's also a possibility of Turkey joining the Council. It is in that setting that the 10 votes might be available for a resolution that is so hostile to Israel that the United States will find it necessary to veto it. Mahmoud Abbas has warned that if, because of the position taken by the United States, he does not get a result from the Security Council that satisfies him, he will initiate a proceeding against Israel in the International Criminal Court. That takes us to the problem that stems from last summer's campaign in Gaza. It was in response to a renewed step-up of missile and mortar attacks from Hamas and Islamic Jihad in Gaza, and the information that became available about the construction of tunnels designed to infiltrate Hamas terrorists from Gaza into Israel, that the Israel Defense Forces initiated a military operation designed to defend the country against the missile and rocket attacks that were taking place and eliminating the terrorist dangers stemming from the tunnels. It was in this campaign of self-defense that Israel took action to destroy the missile launches in Gaza. Given their utter disregard for welfare and even the lives of their own people, the Hamas operatives had placed the missile launches in heavily populated areas, often close to apartment buildings, schools, and hospitals. Their action was clearly in contravention of international law. Here's what Protocol 1 to the Geneva Convention provides in Article 58. And I quote, "The parties to the conflict shall, to the maximum extent feasible, avoid locating military objectives within or near densely populated areas." As Hamas ignored this requirement of international law, the Israeli Defense Forces took truly unusual steps to help minimize civilian casualties. Where possible, Israeli military personnel got in touch with Palestinian civilians in locations that were about to be attacked to urge them to leave these locations. A British colonel with experience in Afghanistan has been quoted as pointing out that he did not know of any army that had ever gone that far in seeking to minimize civilian casualties in areas in which military objectives were located. But that fact did not stop the United Nations Human Rights Council from going into special session on July 23, 2014, 15 days after the Israeli military campaign had started, and following a few hours of discussion and without having investigated the subject, adopt a resolution finding Israel guilty of violations of international law. The resolution did not even mention Hamas. Having found Israel guilty, the Council appointed a commission whose task it would be to find the evidence and determine who in the Israeli leadership should be held responsible. 5 years ago, in 2009, following a similar military clash in Gaza, the Human Rights Council did precisely the same. It appointed a commission to investigate Israeli conduct in that campaign. That was not the only similarity. In 2009, it appointed a person with an obviously Jewish last name to chair the commission, Richard Goldstone. It has done the same now by appointing William Shabbos. His name notwithstanding, Shabbos has a reputation of being strongly anti-Israel. It is evident that the anti-Israel operatives at the UN go out of their way to find people with Jewish names who will sign on to documents directed against Israel. As it is, Judge Goldstone subsequently repudiated the Human Rights Council report that bears his name. The Human Rights Council is scheduled to meet again in March 2015, at which time it can be expected to approve the then newly minted Shabbos report. It will undoubtedly be a report that denounces Israel and accuses individuals in the Israeli leadership of violations of international law, and it will be approved by the Human Rights Council. What is not clear is that what will happen next. Mahmoud Abbas has threatened taking Israel to the International Criminal Court. Aside from the fact that the case against Israel will lack merit, the complaint will raise serious jurisdictional issues, but neither deficiency may stop him. As for the expected action of the UN Human Rights Council, it is well known that the Council ignores the great majority of human rights violations worldwide, but, like other UN institutions, focuses on Israel. Why should that be the case? The answer is that operatives at the UN have been able to develop an anti-US and anti-Israel culture at the UN, a culture that has reached many ambassadors. These ambassadors often act on their own. Their votes do not necessarily reflect the basic outlook of their governments. That is why it is so important to reach heads of government friendly to the United States and non-antagonistic toward Israel and alert them to the votes cast by their ambassadors to the UN. Let us just take a look at the votes cast last July on the resolution that denounced Israel for human rights violations and then appointed a commission to find the evidence. The Council has 47 members. The vote on this latest anti-Israel resolution was 29-1 with 17 abstentions. The single no vote was, of course, cast by the United States. A total of 12 European states, both East and West, serve on the Council. One of them, Russia, well known as a great supporter of human rights, voted yes. The other 11 European states abstained. An abstention at the UN is actually a vote. It is the equivalent of a present vote in the U.S. Congress. It indicates that the state in question does not support the resolution, but does not feel strongly enough to vote no. Japan and South Korea, two Asian states that generally vote with Europe, abstained as well. Why do they abstain rather than vote no? It is the prevailing culture that makes them feel uncomfortable to cast a no vote on anti-Israel resolutions. If we could encourage the abstaining states, all of which have good relations with the United States, to switch to voting no, the result will be 29-18, and much better than showing than 29-1 of last July. But if we applied ourselves further, we could do better than that. I've met with presidents of UN member states who were truly shocked when they were told how their respective ambassadors voted at the UN. Many ambassadors to the UN just go along with the crowd. As for the July vote in the Human Rights Council, someone I know called the president of one of the states that voted yes. The president first did not even believe that his ambassador had voted yes. When that fact was confirmed to him, he assured the caller that instructions would be issued to avoid repetition. Let us consider another case involving the recent Human Rights Council vote, the case of India. Last July, minority parties in the Indian Parliament submitted a proposed resolution similar to that considered a few days later by the Human Rights Council. It was overwhelmingly defeated by India's new majority party, the BJP. Yet a few days later, the Indian ambassador in Geneva voted for the resolution accusing Israel of violating international law. the word for New Delhi may not have gotten to him. Looking at a number of other yes votes, we can find states that have no policy reason to vote against Israel and receive hundreds of millions of dollars in U.S. foreign assistance. In these states, too, there's serious doubt that the heads of government are aware of the votes cast by their ambassadors to the UN. Let me now sum up. There are 2 points that I hope I've made in this talk. One, much of the time and resources of the UN system are spent on efforts to damage the state of Israel and also embarrass the United States. Two, if a consistent effort were undertaken to change UN voting patterns by reaching out to heads of government of friendly states, a profound change in UN operations could be effected. Thank you.
Thank you so much, Ambassador Schifter. I will, as the moderator, I'll take the moderator's prerogative and ask the first question. Can you tell us which members of the United Nations Human Rights Council do you feel who have abstained in previous anti-Israel votes can be turned into a no vote, and which ones who have voted yes we might be able to turn into a no vote?
Well, as far as the abstentions I mentioned, let me tell you who were the members in 1948. Who were the members in July of this year that voted. I mentioned, first of all, Japan, South Korea, and then here are the ones that are members. The members in July. Some of them might be replaced this year because new elections of 1/3 of the new membership of the membership of the Human Rights Council. At any rate, it's Czech Republic, Estonia, Montenegro, Romania, Macedonia, in Eastern Europe, and then Austria, France, Germany, Ireland, Italy, UK. Those are that category. Then, as far as the yes votes, are concerned, it was Costa Rica, Mexico, Peru, Cote d'Ivoire, Ethiopia, Kenya, Sierra Leone, and the Philippines, as well as India. Those are votes that I think could be changed. And what that would mean is that you could actually defeat the resolution.
Oh, we really, really admire your can-do attitude.
I would like to underline one thing, and that is that Mexico consistently votes against Israel and the United States is really, truly shocking, but it's happening. And by and large, it's a product of foreign ministry approach. And this is why it's so important to get through to the president.
Right. We absolutely admire your can-do attitude and your tenacity, your indefatigable, if I can pronounce it correctly, and we would like to help you in any way possible. Do you know if anybody from the Israeli Foreign Ministry is working with their French counterparts in terms of what it is that Mahmoud Abbas is proposing, and whether or not the French are taking into considerations any of the resolutions that Israel should have secure, the prior UN resolutions after the 1967 war, that Israel should have secure and defensible borders?
I was wondering what the anticipated timetable is that they'll be having these votes, so we know how much time we have to work with.
Well, the only thing that we definitely know is that Human Rights Council will be voting in March. As far as the arrangements of the General Assembly are concerned, or for that matter, the Security Council, Council. We'll have to see what Abbas will be talking about on Friday. Right now, nothing is scheduled other than the usual anti-Israel votes, which start at the end of November.
Okay. Thank you.
But there's nothing that has been scheduled in terms of anything other than has happened in recent years. Usually they start toward the end of November with the adoption of usually close to 20 anti-Israel resolutions.
Okay, that's very helpful.
As the new ones are concerned, we have to wait and see.
Hi, Jeff Mausner in Los Angeles. Thank you, Ambassador, for all you've done and all you're doing. Could you tell us how Samantha Power is doing in defending Israel?
Let me tell you that my experience at the UN was that there is very little that you can do in New York in dealing directly with the forces at work in New York. My experience was that when I ran up against a particular problem, I would get on the phone and start calling our embassies in the relevant capitals and get them to make the presentation to the government back home to get directives back to New York and Geneva. I was also in the Human Rights Commission in Geneva. So the point is that the ability of the representative of the United States to influence the course of events in New York is quite limited. It has to be done in capitals. And one of the things that I've found is particularly that does pay off is for members of Congress to make appropriate representations in capitals. Well, you see, the fact of the matter is that the way the United Nations are set up, they now make their own rules, and whatever past agreements are from that point of view ignored. The decision was made, for example, by the UN General Assembly to recognize Palestine as a state. Now, the fact of the matter is that has no legal consequences outside the boundaries of the boundaries of the United Nations. But the fact of the matter is that you have Mahmoud Abbas speaking to the General Assembly, and you just have to accept that is what happens, and you deal with all of this on the basis of the generally accepted current customs, and there is no Supreme Court to which you can turn to present a legal argument on that.
I mean, it's all documented. There's no question. Why doesn't Israel use those legal decisions or those legal agreements to defend itself?
Well, the point is, I keep in mind that, for one thing, we have the creation of the State of Israel under the terms of the 1947 resolution, which provided for the division of the mandate, the mandate of Palestine. Yeah, my hunch is that you have a situation, you're absolutely right. There's a separation here between what it is that goes on in the UN setting and what it is that might be going on in terms of private communications. For example, one of the things that's very clear is that Egypt, at this particular point, has been very much concerned, quite obviously, about the Muslim Brotherhood and friends of the Muslim Brotherhood, and acts accordingly. And the current relationship between Egypt and Israel seems to be quite good. But at the UN, Egypt will be speaking out against Israel. It's a matter of custom. And sometimes it is indeed let me put it this way. When I was at the UN, we used to distinguish between what we called the UN world and the real world on the other side of First Avenue in New York. But the fact of the matter is that the UN world does damage to Israel's image, particularly in Europe. And that is something that is really very troublesome.
Okay. Thank you so much, Ambassador. We absolutely cherish your hard-earned words of wisdom gained through a lifetime of experience. You were in the belly of the beast at the United Nations, and we absolutely are enormously and profoundly grateful for the lifetime of work and dedication that you've put into this effort.